we're going to go through a bit of information today on things you should be thinking about as we wrap up the year. If you can believe it, we are, yes, towards the end of the year. So not only are we starting to think for some of us about New Year's resolutions, but we're also trying to make sure that as we end the year, there's certain things on that to-do list that actually get checked off before we roll over into 2023. So some of the things that we have on our estate planning to-do list. First and foremost, making sure you actually have an estate plan. That is one of the biggest items that we want to make sure every person has up to date and has in place. Point two is, if you already took that fantastic step of actually setting up a plan, we want to make sure that that plan is now up to date. And so what that will look at is, how has your life changed? Are there things that need to be shifted within your trust? And has the law changed? And then, of course, have you checked in with other professionals? So even though we're going to focus more on the estate planning side today, there's other components that need to be done. And then, of course, why Cope and Barger? Why should you choose to work with us or continue working with us above all others? Now, for those of you who don't know me, my name is Victoria. I am one of the estate planning attorneys with the Cope and Barger law firm, and I primarily work with our Northern California clients. With that being said, as you can tell, we are on Zoom right now. And so if you would prefer to be on Zoom and meet with me, we are able to do that pretty much wherever you are. Now, with that being said, I said that I am one of the attorneys. So we actually have 7 other attorneys that are in the firm as well. And so for those of you who are not in Northern California, we have a wonderful team of attorneys that are there to serve you, as well as a phenomenal team of about 40 staff that ensure that we are able to do what we need to serve our clients. All right, so let's start jumping into that checklist. So first and foremost, do you have a plan? What that means is, have you taken the step to actually put an estate plan into effect? Now, for some of you, you may only need an advanced healthcare directive and a durable power of attorney, which we'll go more into depth in just a second. But for others of you, you really need the full estate plan. Now, for those of you that have an estate plan, bear with me as we go through this first part, but also keep in mind this will be a really good reminder of why what you have in place is so important. But for those of you who have no plan and maybe don't even really understand what estate planning is, this is going to be a great crash course in not only what you need to set up, but why the documents are so important. Now, I mentioned that pretty much everybody needs an advanced healthcare directive. So if you are watching this and you do not have an advanced healthcare directive in place already, now is absolutely the time to get one. Not only do we see more accidents occur over the holiday season due to skiing, vacations, maybe you're hanging lights on your house, or maybe you have one too many at dinner and things go wrong. Medical accidents, unfortunately, do increase during the holiday season. But we're also concerned about those of our loved ones that may be older. And in the holiday season, for whatever the reason, we do see more people end up with end-of-life health issues that end up in the position where they need someone else to advocate on their behalf. Your advanced healthcare directive is specifically designed to name a person who can act for you if you can no longer make your own medical decisions. If you are in that most vulnerable of spaces where, again, you can't communicate with the doctor any of your wishes, it is vitally important that you have that person in place. The law had changed back in 2004 to say that if you do not have the ability to verbally tell the doctor who can do this for you, you need to have it in writing. That even goes for spouses. So if you are married, your spouse does not have an automatic right to make your healthcare decisions. If you are someone who just turned 18 years old, or you are the parent of an 18-year-old, you no longer have the automatic right to make your child's decisions. So you need to have it in writing. I really cannot stress that enough, to make sure that whoever you want in that role is going to be there. It goes into action pretty much immediately. What that means is if you have an issue tomorrow and this is in place, it's in action. And again, this is something that everybody needs if they are over the age of 18. If you don't have one in place, now is the perfect time to get started. And if you do have it in place, make sure it is still current. This more goes into the next section, but you really want to make sure that who you have in place is still correct and the different decisions you made within the document are still up to date. Now, we talked about the medical power of attorney, and the sister document, as I call it, to that is your durable power of attorney or financial power. So when you're going through your checklist, do you have one of these in place? If your answer is no, again, now is the time to get one. This is there so that if you are incapacitated, you are able to have somebody else manage your finances on your behalf. This is really important for a variety of reasons. When we talk about incapacity, often people think of long-term incapacity, like having a stroke or Alzheimer's or dementia. But what about short-term incapacity? When my grandma was in the hospital back in 2019, she was technically able to still make her financial decisions and would be long-term. But in the moment, she was in the ICU and struggling with different medical issues. And so by using this power of attorney, even though it was just a short-term incapacity, I was able to make sure her lights stayed on, her phone bill was still paid, and that her general life continued to run smoothly so that she did not have to think about it. This is one of those things that you don't want to wait until you're in the need, because having these documents in place ahead of time not only ensures you remain protected, but it really can give the family a lot of peace of mind as well, because they then don't have to scramble to figure out how are they going to manage your life and how are they going to pay for things. They have everything they need in place to take care of you and those different to-do list items that always come up. Now, let's shift into another portion, and that is, do you need a trust? So for a lot of people, they do need a trust. If you do not have a trust and you are someone who owns property or has more than $184,000 to your name, you absolutely need a trust. And the reason is that we are trying to help you avoid what is called probate, which is a court proceeding that essentially happens after somebody passes away who does not have a trust. A trust is an actual contract. And so if you are the one creating the trust, you are known likely as the settlor. That means you're the creator who actually gets to set the terms and what goes into that document. You are likely also going to be the initial trustee, which means you are the person who will manage and invest the trust assets. But at some point, you need what is called a successor trustee to be put in place. The successor trustee is there to manage and invest and marshal the trust assets once you no longer can, whether because of incapacity or you've actually passed away. Now, the successor trustee is someone who does actually need to follow the terms of the trust. So when we're looking at who should be in this role, you really do want it to be someone who is trustworthy. It's right there in the name. It's all about trust. You want to make sure it is somebody who has a pretty good head on their shoulders. By that, I mean they remember to pay their own bills. They generally have a pretty good management of their systems. Because as somebody is taking over your systems, it's going to be a learning curve. And so if they already are disorganized and a little bit chaotic, that's generally not the person you're going to want in this role on your behalf. And then ultimately, the beneficiaries you name are who get to benefit from your estate once you are gone. So this could be your children, this could be charities, friends, other family, or a combination of all. It could even be your pets. So you really get to set the terms however you want it to look like and to be. The idea is that the control remains with you so that no matter if you are incapacitated, you're healthy, or you've actually passed away, your wishes are the ones that ultimately get carried out. All right. So one of the biggest benefits of the living trust is it avoids the cost and delay of that court process I talked about called probate. Now, the cost of probate is exorbitant. And if you are curious about how much probate can cost, you should go to our website, koppenberger.com, go to the Resources tab and click on Probate Calculator. You can plug in what is known as the gross value of your estate. So that means the gross value of your home, not what equity you have, but the actual value, your cash accounts, all of those different things, and plug it in. Even if you have a trust, I recommend that you do this because it is a little bit horrifying when you plug that gross value number in and see what the cost of probate would be or would have been. The reason I encourage all of our clients to do this is it absolutely reminds you why having a trust is so important. But beyond probate and keeping you away from the court system and keeping your family out of court, we also want to make sure that your privacy is protected. If something has to go into court, it unfortunately becomes a matter of public record. And I don't know about you, but if I kept something private, like my finances, during life, I generally wouldn't want the public to have that information even after I'm gone. With your trust, once you set it up, you are the only person who can decide who else can see it. Your attorney keeps a copy, but other than that, you again get to dictate who's going to see that plan. And it could be nobody. It could be you and us, and that's it. Another layer of having a trust is that you're able to do tax planning. So again, I don't know about you, but I do not like paying a penny more than I have to in taxes, and that'll be the same for when I'm gone. And so within your trust, you are able to set up different layers to ensure that taxes are at least reduced, if not completely eliminated. The tax we are generally talking about is an estate tax, which is what applies to your estate once you have passed away. But some of our clients have charitable giving goals, and so we're talking about gift taxes. Other people have businesses, and so we are concerned about income taxes. Some people are looking at selling homes or stocks, and they're concerned about capital gains taxes. Others are wanting their children to inherit property, so they're concerned about property taxes. All of these different layers of tax components can be planned for within your trust or within other trust documents. And so these are things that if they're of concern to you, whether you have a plan yet or not, absolutely come and talk to us. And then one of the biggest things that having a trust, a financial power of attorney, and a medical power of attorney allow is for you to avoid a court-supervised conservatorship. Essentially, that means you are incapacitated and did not take the step of setting up these documents. And so now you're incapacitated, and we need to ask the court to name who can take care of you and who can take care of the money. This is a position we never want you or your loved one to be in. And so I cannot emphasize enough, if you do not have a plan, now is absolutely the time to get one. And ultimately, of course, we want to make sure that your wishes are the ones actually carried out and honored. This is your estate. This is your life. We want to make sure you have the control. All right. So now shifting to those of you who have joined us that already have a trust. So how do we make sure that for your checklist, you have ensured that your plan is up to date? So first and foremost, congratulations on taking the step of setting up a plan. That is a fantastic thing that I hope you understand took a lot of weight off of your shoulders and ultimately is going to take a lot of weight off of the family or friends that you have entrusted to manage this on your behalf. So we talked about the successor trustees. These are the people who manage things if you no longer can. Are they still the people that you want to be in that position? If the answer is yes, fantastic. You can carry on and we'll go to the next step. But if you review it and your answer is no, who should they be? Who do we want to put in that position to ensure, again, that you and your finances are going to be properly managed in the way you would want? That may be that you had minor children at the time you set this up, but now they're adults, and so you want them to move into this role. Maybe you had parents named, and they have unfortunately passed away, or they're at a place where they couldn't do it. Maybe it's friends who you were really close to before COVID hit, and now you've grown apart. Whatever that no reason may be, it's important to make sure that we get the right people in place to take care of you. And then for those of you who have minor children or even minor grandchildren and want to talk to your kids about this, are the guardians of your children still the ones that you would want? Now, when we're talking about guardianship, this unfortunately means you as the parents have passed away and your kids are going to be left vulnerable. The guardianship role is something that we absolutely want to make sure we get as close to perfect as we can. Because essentially with the guardians, even though we know we could never replace the parents, we want to get as close to that as we could so that your kids continue to be raised in a way you would want and that they are going to be protected in a way that you would have wanted. Again, if the answer to this is yes, that they are still correct, great. Again, we'll move forward. If the answer is no, this is something to really stop and think about. Because again, things unfortunately happen overnight. And this is one of those things we do not want to see happen to you. What I'm talking about is the guardians are not correct and either aren't valid anymore. Maybe it was your parents and they've passed away. Maybe it's people who have moved out of the state. Maybe it's people you aren't even close with. But now your children are either left with no guardian in place or the wrong guardian in place. So again, if you are in the position of having minor children, or you want to make sure that your grandkids would be protected under your children's documents, now is the time to have this discussion and really take a look at those documents. All right. And then we talked about your healthcare representatives. Again, this is a very vulnerable place if you are in the position of needing a healthcare representative to advocate for you. It means you cannot do it for yourself. So this, again, is something that you don't want to gamble with. Make sure that your healthcare representatives are the ones you still want. Again, if your answer is yes, fantastic, you can have that peace of mind. If your answer is no, again, who should they be? Generally, when we're looking at healthcare representatives, we're looking at people who are going to do okay in a healthcare capacity. By that, I mean, they don't pass out the second that they walk into a hospital. That may not be the right person. Generally, it's someone that's a little bit more emotionally sound. So it's not that they'll lose their head or their cool every time an issue or decision has to come up. So when you're thinking about who should be in this role, those are generally the things we advise you to think about. Okay, and are your beneficiaries still the ones that you would want? Now, this has multiple layers, so let me walk through a few. First and foremost, are the beneficiaries who you want, period. That means the people that you had originally named, do you even still want them included in the documents? If the answer again to that is 100% yes, we move forward. But for a lot of people, beneficiaries are something that actually change more frequently than anything else. The reason is multifold. If you have charities in your trust, a lot of times people change their charitable intentions throughout their lifetime. One of the things that we can create for you is what is called an exhibit, where you list these charities. The benefit to having an exhibit is it is, generally speaking, something you can then modify yourself going forward. So if you have charities in your trust and you're looking to have them updated, make sure to talk to us about creating this exhibit. What if it was that you had your minor children named and now they're adults? Within that, there's a few different options. If your children are now adults, they can either inherit outright, which means they just inherit. It goes into their account. They do whatever they want to with it. Or you can have it set up in what is called a lifetime protective trust. That lifetime protective trust is there to insulate their inheritance. In most cases, they can still be the ones to manage the inheritance, not all cases, but most. But it ensures that their inheritance will not be taken away in the event of a divorce. It could not be taken away if they started a business and it went under and now they're filing bankruptcy, if they were sued, or if they owed back taxes. Nothing can touch that inheritance. And so again, when we're talking about your beneficiaries, the people might still be the same, but the protections and provisions around them might be different now. So that is something that you don't know if you have what you want in place to come and talk to us, or if you know you don't have what you want in place, absolutely come and talk to us. And then a big one, are your assets properly titled in your trust? So just because you had a trust set up, which again is a fantastic step, does not mean your homework is done. In your trust signing appointment, you likely went over the fact you need to put certain assets in the trust. First and foremost, your primary residence or any other real property need to be in the name of the trust. If you had done a deed, but then refinanced and never confirmed the property went back in the trust, it is very likely unprotected right now. So if you are someone who is refinanced and don't know if they put the property back in the trust, you need to make sure we check that. A lot of people don't realize with refinances that the property is pulled out, but again, not actually put back in. You also want to make sure, generally speaking, that your checking accounts, savings accounts, and non-retirement investment accounts are in the trust as well. If you do not know, or if you need help on how to do this, absolutely come and talk to us, because this is something we would be more than happy to walk you through. Now, we talked about some of the life changes that may have occurred, but what changes, if you have one of our Koppenberger trusts, do you need to be aware of when it comes to the legal side of things? The first thing is what we call our Medi-Cal authority. Now I'm going to sidetrack just a little bit for a second. We have what is called a Medi-Cal trust that is separate from our revocable living trusts. The Medi-Cal trust is one that is established in order to protect your assets, allow you to keep your assets, and qualify for Medi-Cal if you needed long-term skilled nursing care. Now, for a lot of our clients, they are not at the point that they want to set that type of trust up. It is a more costly trust, and normally it's a more involved trust. But we now have language that was starting to be put into trust starting in 2019 that says if you lose the ability to sign or set up that kind of trust, your financial power of attorney and successor trustee could do that on your behalf. But that is language that you have to put in your revocable trust and in your financial power of attorney. So if you do not have this language and you end up in a position that you need that kind of planning but can no longer sign documents, we unfortunately can't do anything to help you. So this is language I encourage, if you have not seen us since 2019, absolutely come in and see us now to make sure we can get that put into place. The other component that has changed about the same time frame, but just a year later in 2020, deals with the Secure Act. What this is saying is that the Secure Act changed IRA and 401k rules to say that when you inherit an IRA or 401k, unless you're a spouse, you now have to withdraw the amount within 10 years. If you have a trust that was done before 2020, you probably have outdated retirement language that deals with IRAs and 401ks, especially in connection with those lifetime protection trusts I talked about just a second ago. I know that this can be often very complicated and overwhelming. So if you don't know if you have this language or you don't know if you need this language, come in and let's make sure you have a review so that we can ensure it is properly put in there if it is needed. And then the last thing that changed, again, actually back in 2021, deals with property taxes under Proposition 19. Proposition 19 changed inheritance rules to say that the only property that is even going to be able to keep your property tax basis is your primary residence that is inherited by a child who then claims it as their primary residence. Now, this is generally speaking very easy if you have just one child. It's up to them if they want to live in that residence and keep your property tax basis. But the issue we have been seeing is for people who have more than one child. Let me give you a quick scenario. If you have, let's say, 3 children and you leave that property to them equally, and one says, yes, I want to live in that property and keep the property taxes, but the other 2 say, no, we'll give you our portion, but we don't want to. The county will reassess 2/3 of that property. So how do we avoid that? We can put into your trust what is called right of first refusal language. That essentially in that scenario means the one who would have wanted the property can compensate their siblings for their share. So it could be in cash or stocks or some other type of monetary balance. And they could then keep the property. That means they would keep 100% of the property taxes at your current level. So that is something that you can absolutely include. If you are concerned about that or you want to talk more in depth about it, please come and see us. And then as we're going into the holidays, for many of our clients, they are now going to be gathered around with their family. So one of the things on your checklist should be, have you made and recorded memories? A lot of our clients, the best thing that they could leave behind are the memories that they actually put in a recording. That could be a written record, that could be a video, that could be photos, whatever that looks like. We want to make sure that, especially during the holiday season, which is such a great opportunity for many people to capture these memories, that you remember to do that. This has nothing really to do with estate planning. This is more about the legacy side of things. We were founded under the belief that every single one of our clients have a legacy that matters. And a huge component of that legacy, forgetting even the financial side, is the memories that you have. So we very much recommend, as again, you're going through the checklist and what to be thinking about, that this be on the forefront of your mind. How to make sure as time goes on, you can really capture the things that you have gotten to experience with your family. You have gotten to hear about maybe some of their past experiences. Maybe it's about the history of your family. Whatever that looks like, again, we just want to give you a reminder to keep that at the forefront as we come into this holiday season. And then, have you checked in with other professionals? So even though our primary focus here is estate planning, one of the greatest assets that we can give our client base, is the fact that we have a phenomenal group of professionals beyond just the estate planning side. And so we want to make sure that you've checked in with your professionals that are outside of the estate planning side. So first and foremost, have you checked in with your CPA? As you're coming to the end of the year, it's really important to start making sure you are getting your tax components under control. If you are concerned about taxes or minimizing the taxes you will owe, you could start looking at gifting. But within that, have you maximized the gifts that you're allowed to give without ever telling the IRS? For the year of 2022, you are able to gift individuals up to $16,000 without ever telling the IRS that you have done so. They don't need to tell, and you don't need to tell. So as you're coming to the end of the year and you're looking at potential gifting, have you hit that $16,000 per person? If not, and that's what you are wanting to do, again, make sure you get that done by the end of the year. Have you checked in with your financial advisor? One of the big things here that we want to make sure you are aware of is, in your retirement accounts, have you taken your required minimum distributions for the year? We do not want to see you hit with any penalties in the next year. And so make sure to check in with an advisor to make sure you've done this. Make sure that whatever your financial goals are, that you are still on track. And this can be a great time to have essentially a revamp, so to speak, of what are your goals for 2023? Are your finances and that plan on track for your 2023 goals? Have you checked in with your insurance carrier? A big thing I mentioned at the very beginning is that we see accidents occur. This is both to the person, but it's also to the vehicle. It can be to the home. There's a variety of different accidents that unfortunately occur. So are you going to be fully protected this holiday season, both personally for a person, but also for your vehicles and your home? This is something that we don't want people to wait until it's too late to deal with. So again, as you're going through your checklist, and I know it can get overwhelming as I keep adding things to think about, do make sure you at a minimum just do a quick check-in so that you can have that peace of mind and really enjoy this holiday season. All right, so we went through quite a bit. Hopefully that checklist was helpful to make sure that you can say yes to all of those, or if you've said no, that we have you on the right track to saying yes to everything. But why should you work with Koppenberger? Or if you already do, why should you continue to? One of the biggest benefits to us is we are very accessible to our clients. So we are here to make sure that your plan is reviewed as often as you need it to be. Because you just watched this webinar with me, you actually get a free review. And so we really do want to make sure that our clients know they can come and see us at no cost. And so anytime you need a review, just attend one of our education events or watch one of our webinars that have been recorded and posted online to ensure that you can get that at no cost. We again are also able to recommend other qualified professionals that are within our Koppenberger network and family. And so if you are concerned that maybe I don't have a good CPA, or my financial advisor retired, or I don't know if my insurance carrier is giving me all the options I need, come and talk to us. We are happy to recommend people in your area. But ultimately, we are there when it counts. One of the worst things I hear from people who worked with other attorneys is, I can't get a hold of my attorney. I don't know if they're still working. I don't even know if they've passed away because I cannot get a hold of them. One thing here at Koppenberger is you can get a hold of us. If you are one of my clients and I'm out of the office, I will ensure one person or more on my team is there to take care of you so that we do not miss a step when it comes to the service that we offer our clients. And then, of course, we have been open for quite a while. And like I mentioned at the beginning, we have 8 full-time attorneys. What that means, again, is not only are we accessible, but we have a lot of experience here dealing not only with things that are very cookie cutter and very easy start to finish, but those very complex situations. We are able to help our clients with the ins and outs of estate planning because we continue to educate ourselves so that we can in turn educate and inform our clients. I hope that you enjoyed this webinar. Thank you for taking time towards the end of the year to spend with me. For those of you we got to see this year, thank you for coming and spending extra time with us. For those of you we haven't seen yet, there is still time. And for those of you that may be traveling and it's a little crazy, we cannot wait to see you in the new year. Again, because you watch this webinar, you do get a free consultation. So if you are someone who's a client, we can review your documents. And if you are here to see if we're someone you want to work with, we cannot wait to talk more with you. Now, if you do set up a consultation, especially if you are someone who is not a current client, if you have any existing estate planning documents, please do bring those so that we can make sure either you're perfectly in shape, we don't need to update anything, or here's what we would need to update. We also have a confidential data questionnaire, or CDQ. This is really important whether you are a new client or a current client, because it allows us to make sure all of the contact information is up to date, people's names and information are up to date, and that your assets are up to date. So for those of you who are current clients and have filled this out before, it might be a little bit redundant, but we are so appreciative of you taking the time to still go through it. And ultimately, what questions do you have for us? We're here to answer questions. That's one of the favorite parts of the job, is making sure we can answer client questions and give them the peace of mind that they need, especially as we go into the holidays. So thank you again. I'm going to switch back to the contact page. That way, if you are ready to set something up, you can reach out to us. But I hope you have a safe and happy holiday season, and I look forward to meeting with you.